I've heard that in the state of California, some probate cases do not have to go through a court hearing process. When is a court hearing required, and when is a court hearing not required? Hello again, this is Certified Probate Real Estate Specialist Daryl Williams with Win-Win Realtors here in Southern California. If you are new here and you like our content, be sure to like, share, and subscribe. Let's get started. Understanding when a probate hearing is necessary can make the probate process a lot less stressful. In the state of California, when a person dies with assets solely in their name and there isn't any designated beneficiary, a probate and a probate court hearing will be required in order to distribute the decedent's assets to their heirs or beneficiaries. A court hearing will also be required if the value of the assets exceed a certain amount. That threshold amount is subject to change depending on the date of the decedent's death. If the decedent's assets are less than the threshold amount, you can use what's called a small estate affidavit in order to transfer things like money and personal property, excluding real property. All this can be done without a probate or a court hearing. Thus, if an estate is valued over the threshold amount, which right now is $184,500, a probate and a court hearing will be required. In a non-complicated probate administration, there are typically two probate court hearings. The first hearing is to appoint the executor or an administrator the authority to manage the estate. And the second hearing is to approve the final accounting and distribution of assets to the heirs or beneficiaries. Normally, this hearing, the final hearing, will also close the estate. Other hearings that may be required are for things like the sale of real property, the approval of attorney's fees and personal representative fees, any dispute resolutions. Basically, whenever there is a dispute or a problem in a probate, there will likely be a court hearing. Question of the day: have you ever been an heir or a beneficiary of an estate? If so, did you attend the initial hearing? Let us know in the comments below. The bottom line is, here in California, a court-supervised administration provides the legal framework to appoint an administrator or an executor of the estate to oversee the estate administration and make sure that the law is carried out to provide a means for resolving disputes and to make sure the process is open and transparent. I'm Daryl Williams. This is Win-Win Realtors TV. If you know someone that's in the Southern California area and they're dealing with a probate administration, they possibly have questions about probate real estate, please share this video with them. If you have any questions for me, feel free to reach out. My contact information is in the description. This video has been for information purposes only. It is not legal advice. I am not an attorney. If you need legal advice, please consult an attorney. If you need a probate or an estate planning attorney here in the Southern California area, feel free to contact me for a referral.